ladies and gentlemen. Welcome again.
Thank you for staying.
This is going to be quite a challenge. We have a wonderful panel, but more panel than time. So unfortunately, I have to insist that everybody strictly limits the interventions to the 8 to 10 minutes that have been suggested so wisely by Ioannis, because otherwise we may end up with an empty hall because people may really have to leave. Thanks also to Ioannis and Lisa for organizing this and having me here. I have no need for a transparency declaration. As you may know, I've been a member of the bar, and I've been for many years head of a competition authority. I may add that in a previous life, I've also been more directly involved with 2-3 venture capital type initiatives. First, we would like to give the floor to Daniele, who will tell us the way he sees it from the Commission's point of view. What is the present state of thinking? Because the whole panel is basically trying to look at the state of the law as it has developed over the years, in the light and in perhaps contrast to what we discussed in the previous 2 panels. Daniele, you have the floor.
Thank you very much, Jacques, and thank you all for having me today. I don't know if you can see me well.
I can.
I regret not being in London, but I was just at another panel here in Brussels, and that's hence the tie. I don't usually wear ties at home. So I will try to go straight to the matter in view of the fact that I'll try to stick to my timeline. And I think in terms of disclosures, I will have to confess that I was one of a group of people that did draft the famous or infamous for some Dow DuPont decision with the 4-layer theory of harm, which touched on innovation. So I consider that decision an important step in the innovation analysis and in the analysis of dynamic effects by the Commission. I think notably that's a case which followed a string of cases where we started to look more carefully at innovation and at dynamic effects. And I think that's the one decision where we try to also conceptualize our doctrine of effects on innovation of mergers in a way that was a bit more elaborated, and also that allowed us to run also an innovation theory of harm, which was in layer 4, not immediately linked to product competition in the market that was specified in terms of a theory of harm. I was recently at an event with some of the people that I see on the panel where, there was a bit of a state-of-the-art taking stock moment where we saw that in the past years after that decision, when there was not a lot of literature on these topics. I think now there's a flourishing amount of literature, and I think what is key for us is that the issue of dynamic effects and innovation has come to the fore as a key issue to address for us as we review the merger guidelines. So I will assume that everybody knows the Draghi report and what it calls for, but I think it's been the opportunity for us to take, let's say, the policy road to set up a process for a very ambitious revision of the merger guidelines. And we launched a public consultation last spring. And if you look at the papers that we published together with the public consultation on the initiative, I think that we touched upon a lot of topics. So it's a very broad consultation where we have a specific paper that touches upon dynamic effects on innovation specifically. That's obviously because when you think about not just the policy that we have done through cases, but the policy that is in our books. So in the guidelines today, if you read the guidelines, they essentially say here and there innovation, in very few places. And at the very beginning, our horizontal merger guidelines say, oh, whatever we say about prices, assume it to be true also for innovation. We may do innovation at some point. I think that the development of our case practice and also the doctrine that is out there, the economic doctrine that is out there, I think warrants a bit of a more dedicated approach in our guidelines. And that is why we are putting a lot of emphasis in this process on this issue. Also because if you look at the literature out there, I mean, the idea that, you have a horizontal merger and you can expect that it will, in principle, as a first order effect, create a negative effect on prices. That may not hold true for innovation. Does it hold true for innovation? There may be caveats on when it holds true for innovation. And I think that the literature, I mean, we've heard, I heard one paper quoted recently that has interesting results about what we can expect as a general first order effect. And that is why, in parallel to the initiative on the review of the merger guidelines on the policy side, we are also working with a number of academics and with the contractor, which is Oxira, to do a very ambitious review of more than 380 papers that have been published on the topic, to develop a conceptual framework that can assist us to address this in a systematic way and to translate it also in concrete policy rules that are easy to apply and easy to understand for stakeholders and make our prospective analysis more predictable when it comes to dynamic effects. I think I cannot offer much by means of where this process will land, because as Matthias, who's also in the team and he deals with these and other topics mentioned, it's an ongoing process. But I think that makes the discussion that is happening in the academic world as well very relevant to inform our discussions as we review our policy. What is clear is that innovation and dynamic effects will not be an afterthought, will not be we apply the same framework, mutatis mutandis, but we aim at giving concrete guidance specifically on these types of effects. And that's why we also will continue to engage with the range of stakeholders also in the coming months. We had a public consultation on the papers that we published, but now we are doing bilateral engagements. We're participating to a number of events, and we will host 2 workshops here in Brussels, one of which will be specifically dedicated to this topic. And we aim at publishing our draft guidance in spring next year to gain feedback on the practical way in which we will try to translate all this apparatus, including the academic contributions that we are reviewing, into concrete rules. One thing that I want to report to conclude from the public consultation that we just had is that, you see that there are 2 strands of thought in the public consultation. We have certain responses that essentially say that the Commission may have overlooked the positive effects on innovation of certain deals, so dynamic efficiencies mostly, and call for a more open mind when it comes to assessing whether scale can bring to more incentives to innovate for market players. And on the other hand, we have a number of sessions that instead say that our static approach has essentially made us overlook many deals, especially in the digital space, where we should have been more forceful in our interventions in the past 10 years. So I think it's interesting to see this lively debate. Obviously, it's also a very insightful experience to think that we started our enforcement upgrades in the field of innovation with the idea that reduction of the active players in innovation in an industry or in a specific market can be assumed to lead in general to less innovation. the debate has since moved forward a lot, and now I think that there seems to be also in the policy discussion some corners where there is the opposite assumption that scale is good or always good for innovation unless the contrary is proven. So I think it's a debate that when I look at what comes in from the stakeholders, does not seem to go in the same direction as some of the literature that we are surveying, but that makes these times much more interesting for us and the task we have ahead of us.
And that's hardly surprising. No, I think this workshop is one of the many occasions where you will hear how much we look forward to the new guidelines, and also how much we need them. Because we could have been spared the whole Alstom Siemens saga if at that time people could have looked at guidelines that were in line with the practice. The practice went ahead of the guidelines, which is a quality, but it has created its own problems. Now, in the previous panels, we have already several times referred to the US experience and how much we can learn from the US experience, and occasionally also the other way around. We have the pleasure of having with us, at least online, Fiona, who will look into this within the time frame I can grant her. Please, Fiona, you have the floor.
Wonderful. Thank you very much for the invitation. I am happy to be here. Can everybody hear and see?
Yeah, at least I can.
Super. I will tell you just a little bit about dynamics in merger analysis from the perspective of the US and the US merger guidelines. Sorry, let me try to make this work. Okay. I think just to set the stage, I think that the dynamics in merger guidelines may be a bit more of a novelty for the legal side of the house than the economic side. In economics, we had to cope with dynamics in merger and other parts of antitrust when we invented game theory in the 1970s and 80s. So exclusionary strategies in particular, predatory pricing, wars of attrition, many models of exclusionary conduct, unilateral issues like endogenous sunk costs, these are all strategies that take place over multiple periods of time. And economists are trained to look for the next equilibrium. You change something and you look for the next equilibrium, and perhaps to a lawyer or regular business person that seems like there's no dynamics, but of course you have to, in real life, you have to get from one place to the next, and so that does create a dynamic setting. But it's not new from the analytical side. It's a familiar difficulty. I think actually what Aviv said earlier is important, that empirical analysis of this stuff is much, much harder than theoretical. And so once we had the empirical revolution on the static side, it's very difficult to take that empirical revolution to the dynamic side, and that's why you end up back with documents and strategies and the manager's views of what is going to happen. Let me tell you just 3 things from the merger guidelines, 2023. Potential entry, platforms, and entrenchment. So first, potential entry, guideline 4 says mergers can violate the law when they eliminate a potential entrant in a concentrated market. Now, why is that dynamic? Well, the potential entrant has not entered yet. And if they had entered, they wouldn't be potential, they'd be actual. And therefore, a potential entrant is going to cause all kinds of difficulties evidentiarily, because it's speculation as to whether they would enter or not. Now, speculation, of course, is a bad word. Maybe that means it doesn't count at all, but we don't want to limit our analysis to only firms that are presently in the market, or we miss this dynamic consideration of who's the next entrant, who's got the capabilities, who's got the incentive. If the market evolves in the way that people expect it to, then what firms would be well positioned to enter. So this is a really important part of merger analysis, and one that the merger guidelines explicitly say matters. And I think that's very important, because otherwise courts, I think, sometimes are reluctant to grant a lot of weight to an event that hasn't happened yet. A second part of the merger guidelines that's very important, that has to do with dynamics, is breaking ground on a guideline about platforms. So now we have multi-sided platforms, and we're going to look at competition on the platform, between complements, between platforms. And the important element of that from the perspective of the dynamics is that these platforms typically have network effects, and so you get tipping. And therefore, if Google buys DoubleClick, everything looks very good and competitive, as Oliver pointed out, until you get the funneling of all the demand into the pieces that Google owns, and then you get the market to tip, and suddenly you don't have competition anymore. You have a dominant firm or a monopoly. So just explicitly acknowledging that platforms are there, how we're going to analyze them, again, gives a court of something to hang on to, that this is important, and then whatever we're going to say about the static and dynamic elements of a platform belongs in the conversation. The third one I wanted to mention is entrenchment. This, I think, is the most edgy of the guidelines in the U.S. merger guidelines because it really is new. The stuff about platforms the guideline doesn't conclude all platform mergers are bad or all platform mergers are anything. It really just sets up a framework in which to analyze platforms. And now we've had so many cases about platforms that everybody is on board with that being a necessary thing. Here, the entrenchment is a new element to the U.S. merger guidelines, and the idea is that a merger can violate the law when it entrenches or extends a dominant position. And that is a lot different from monopolization. That is a lot different from market share necessarily, because if I'm entrenching, I'm deepening something. I'm not necessarily widening it. Extending might be the widening. And this can cover a wide range of kinds of transactions and inevitably folds in the dynamics. So an example, a recent one would be United Healthcare wanted to buy a data clearinghouse called Change. And the concern there was that United would be able to use the information in Change to learn what all of its competitors were doing, and that would enable it to copy them, exclude them, generally take that asset and use it to monopolize the health insurance market or to entrench its position. So there again is a setting where the dynamics can be usefully incorporated. And I think this is an area to watch and maybe something for the European Commission to think about, because this is, as I said, the most new and different on the US side. The last thing I wanted to mention is work that I've done with Susan Athey. This is a paper we wrote a few years ago called Platform Annexation. And it's not something that you don't see too often in the economics profession. It's not a formal theory model. Neither is it an empirical paper. It's really a meta theory model trying to propose an umbrella structure in which a lot of our theories, formal theories, can fit. And what it tries to show is, look, if you have a certain kind of merger with a platform, let's say a tool, something that users of the platform might use as a tool that enables them to multi-home and place their ads across lots of platforms or work with a variety of different platforms in their industry, that can be taken by a platform that's not perhaps a monopolist yet, but take that tool, distort it, use it to favor themselves, and cause tipping such that users don't want to use other tools because they don't give access to its platform, and its platform becomes more powerful because it's funneling all the users from the tool to itself. And that meta paper, as I said, incorporates a bunch of different models, and all of those are dynamic. This is not something that's happening at the moment of the merger. This is one of these tipping kinds of phenomena that's going to play out over time, possibly with more than one merger. And so I think this is just a helpful kind of framing. So that was really what I wanted to say about the U.S. merger guidelines. I think dynamics is extremely important to put into your merger guidelines, but it's also a very delicate issue, because if you require too much specificity, no one can do that. And so then it will matter a great deal whether you put the burden for proving something on the government or on the firms, because whoever it's on, they will fail. And so when you have a very specific requirement to predict the future, that's going to be an insurmountable burden most of the time. On the other hand, if you say you don't have to predict the future, you can just claim anything, then you kind of have the opposite problem. Everybody's claiming things and they don't have much of an evidentiary base. So that sweet spot in the middle, where there's some evidence from the way the industry works, from the incentives of all the parties, from the internal documents, that seems to me to be the place to try to get to. And I'm not quite sure how you write merger guidelines to say that, but I am sure Daniele and his team will be up to it. Thank you.
I couldn't agree more also on the fact that it has to be done within a time frame, as has been mentioned in the previous panel as well. With the pressure we have to reduce this ever-extending period of pre-notification discussions, and I think we are now getting there, means that you have less than 2 to 3 months to come to what the decision makers need to decide upon. In my case, we then in the end had usually about 3 to 4 days. So that is the reality of merger control. And then a framework will be extremely welcome, and we will not necessarily. It would be nice to have also a general theory, but it's the framework, an operational framework we are indeed, I think, looking for. Now, some people may be surprised that it is not Eleanor who is asked to inform us about the US guidelines, but you are especially well placed to discuss the impact it all has on convergence and cooperation. You have been following and helping to guide the cooperation now for so many years. Please, you have the floor, but you have to unmute you. Could you unmute Eleanor?
Sorry, okay.
Yes. Now we can hear you.
You hear me now? Okay,
Yep.
Thank you. Thanks very much for inviting me. I would like to expand the discussion, talking about dynamic competition, not just from the merger point of view. I'm going to bring in also some monopoly cases to talk about the extent to which we already, both sides of the ocean, we already have a good framework for bringing in the dynamic effects. I want, first of all, to talk a little bit about history and the idea that we have, which is not quite right, that we focus only on static. Second of all, to talk about some cases, both monopoly dominance and mergers, as to how the dynamic competition comes up. And thirdly, the subject is with Draghi on the table. That's the whole subject. So for a general theme, my general theme is don't throw the baby out with the bathwater. Don't throw good enforcement out with speculative ideas that mergers to larger scale are probably going to be likely to cause the dynamic innovation that is needed, so to speak, for better competition against US or China. So, number one, on history, and this is about US. For many, many decades, all sorts of dynamic competition was on the table. It was only put off the table for mergers by the 1982 merger guidelines, when they read in terms of quite static paradigm. And indeed, in the 1982 merger guidelines, it basically says, with a little footnote, that all the authorities are worried about are mergers that lead to cartel-like behavior. Almost, period. To many of us who were practicing competition law at the time, that was a shock. I had some correspondence with Frank Easterbrook at the time, and I said to him, "Isn't this all just static?" And he wrote back saying, "No, it is a problem of limiting government intervention. What it does is it preserves all the dynamic competition that is going to happen from the freedom of competition in all the space we have to do mergers that are not prohibited." And that indeed is the category for dynamic competition to a large extent, an area where we do not enforce. I'm now drifting away from the merger guidelines, but to this point, that is a huge area in which we do not enforce because we want the dynamic competition to happen. In US, it's, from my sense, way too big, but the Trinco case is a good example of it, saying we want firms to have a huge amount of space to do what they think is best. Our predatory pricing law is really the same thing. We want firms to have the freedom to engage in low pricing, and if law is too interventionist, it doesn't allow that. As time went by, of course, the merger guidelines caught up with the fact that they wanted to control unilateral effects. Unilateral effects were actually controlled before the 1982 guidelines, but that was just dropped out of the guidelines entirely. It was not called unilateral. But before the 1982 guidelines for merger analysis, when you would see two big firms in a highly concentrated market with high barriers merging, we talked about the quality of the competition rather than the price raising effect that would be affected by taking that competition off the market. A lot of the treatment of what can be an offense both on monopolies and mergers related to, especially in earlier days, taking a maverick off the market or squelching the maverick. So for my second category, I want to look at some particular mergers. And cases. And this, again, it's along lines of how do we treat, and this is both US and EU, how have we been treating dynamic competition? I think that the US AT&T case, which was settled in 1982, is a very good example. It's an example of a company that owned the whole industry, both the long distance and the local, and the manufacturer of all the equipment necessary. And the proposition was this was anti-competitive, but the proposition was also AT&T was taking a huge amount of actions to keep new technologies off the market. It was trying to keep MCA and microwave long distance technology off the market by many restraints. It was always recognized that if AT&T were broken up, it would lose some dynamic efficiencies and maybe important ones from Bell Labs because it could not anymore do the basic research and appropriate all the gains from that basic research. And that was really an important point. And AT&T raised it and was, until Bill Baxter came in as Assistant Attorney General and sat down with the president of AT&T. AT&T was really arguing dynamic competition. You cannot touch us. And I think in the aftermath of that settlement, which was a breakup, that people agree that had to happen. That was a good thing to happen from the point of view of competition. It was almost necessary to happen to keep AT&T's feet to the fire and making even the better long distance lines and being up to date with world competition. And that the loss of the ability to appropriate the basic research was unfortunate, but a necessary loss outweighed by the gains. Other cases that were in the monopoly dominance area are all about the suppression of innovation by dominant firms. And I'm going to bring that back to relate it to mergers in a few minutes. The cases on monopoly or abuse of dominance are littered with the squeezing out for no good reason except to squeeze out the rivals. The Microsoft case, very important in this line. The EU Microsoft case shows very particular products that were actually Sun Microsystems, Novell, dropped off the market because of Microsoft's predatory practices. The current, up to date, pretty current, but we're waiting for an ECJ decision in Google Android, shows the extent to which Google Android was suppressing the competition in alternatives to Android through doing the Android forks. An important suppression of competition in an area where competition was needed. On the merger side, I guess I'm losing time, so I can't go into cases, but I think Illumina Grail is a very good case of how innovation was forefront in the case. One way to frame the case is to say, would we really be saving lives if we let Illumina and Grail have this stronger integration, the total purchase? Or would we really be saving lives by keeping the dominant firm Illumina, which owns the DNA sequencing necessary to the downstream firms, which Grail was in on the early detection of multiple cancers through blood samples? Would we be gaining in innovation and dynamics by prohibiting the merger? And again, I think that at least many commentators were quite convinced, and some within the Illumina Grail corporate structure itself, convinced that the better result was to keep the two separate, and it's a better result on the innovation side. I'll say one more word about a type of merger which relates very much to innovation, because I think on the merger side, the startups and killer acquisition mergers are very difficult to handle because you can argue innovation on both sides and speculation on both sides. And you can certainly argue that, for example, and the example I'm going to give is if Microsoft and Google were to each had a policy like Meta Facebook did to vacuum up all startups in order to keep them off the market and growing into challengers, that would seem to me to be sufficient evidence to say, since the companies, by definition that I gave you, since the companies want to keep the new startups off the market because they are fearing of challenging them, that is a pretty good sign that what they fear is the reason for the merger and a good reason to consider prohibiting it. There are many kinds of cases in between, and that would just be an easy one, which unfortunately our court, which just handed down what I think is a wrong decision in FTC against Meta, it could have dealt with that issue but didn't. So my last point is really bringing us back to, with Draghi on the table, the Draghi report on the table. And here Daniele said there are some corners that say scale is needed, scale is good, innovation, the better innovation will come from scale. And I want to say here that I think that there are some corners in which they're presenting dynamic innovation as a new issue and as a new way to appreciate positive effects of often it's mergers and often it's very large mergers. And I would recommend great caution in accepting that point of view. And I think that this seminar itself has shown the many ways in which the law with the economists is very capable of handling the problem. The one point I want to add is I want to bring together the dominance cases and the merger cases to say this. Those dominance cases show us how the companies that get more market power are even more likely to use their power to suppress the entrants or to suppress the smaller firms that are more likely and have more incentives to do the dramatic dynamic innovation. And so a theory of harm of mergers that relates to innovation ought also to include the harm of expected suppression of innovation of the sort that we see in all these cases. So when I say don't throw the baby out with the bathwater, I mean sometimes the bathwater can get dirty and murky, but there is a real competition baby that has to be saved. Thank you.
Thank you very much. And thank you very much for reviving our memories as we did not invent all these problems in the last few years. Thank you very much. Now I would like to give the floor to Gonenc, who will discuss the Draghi report. It is now fully on the table.
Correct. Thank you very much. I'll talk about the Draghi report. I'll also talk about the matter of innovation defense in merger control particularly. It's an honor to be here, and especially an honor to be at my own faculty where I had my PhD on the topic of innovation in merger control. I published a book on innovation paradox in merger control, and this is largely discussing the disparity between the innovation being used as a sword by the enforcers disproportionately to its ability to being used as a shield by the Defense Council. And then I proceeded to publish articles around this book, most recently with David Teese at Jacques Lab in July, I think 22nd of this year, where we're discussing further issues of benefit in innovation theories being explored in the merger control context. We're particularly underlining certain points that I will try to explain without taking too much of your time. But one interesting note that I wanted to share from practice, even before getting into the Draghi report, is something that I had not realized when I was underlining this disparity between innovation being used as a sword by enforcers and not equally efficiently as a shield by the attorneys, is that the Defense Council in practice, so I'm also an attorney, the Defense Council in practice always hesitates to mark merger control matter as an innovation-related merger control matter. They want to avoid that label if they can, because as a shield it means not much, the argument on innovation, whereas as a sword it suddenly is golden. So if they go to their client, if I go to my client and say we need to grab the bull by the horns and we need to introduce the innovation defenses in here, and we need to explain why there is a potential dynamic efficiency gain, and argue all of this with non-static economic analysis, particularly engaging interdisciplinary tools, the client will go, do we have to? The client will not want to profile it as an innovation matter, as a matter that has in its heart innovation, because the minute you do that, you're basically in a swamp. The authorities will find that it is quite easy to rely on speculative argumentation on innovation matters, while your innovation defenses will be dismissed quickly. The result of this is that static analysis tools, static economic analysis tools cannot be left even in innovation-intensive merger control files. So we keep on concentrating on costs and prices and market definition, what have you. Whereas if early on in the process this could be embraced, then I think a new spirit of approach will kick in, and this will benefit the agencies reviewing the filing as well. But for that, there has to be a potential for adoption of innovation defenses, which is not very available at the moment. So going back now to the Draghi report and how does it play into all of this, basically the Draghi report puts the problem as a systemic failure to scale and commercialize innovation in the EU. That's the problem. And the result of it is a potential for the EU to lose its sovereignty economically. The economic sovereignty is largely dependent on innovation because that's the driving force of economic growth now. There was strong external demand in the past, which is not present for the EU anymore. There was access to cheap energy, which is not present anymore. There was geopolitical stability, partly also triggered by the very project that is the EU, that is not present anymore. So we need green pastures, and that can only be obtained through innovation-focused strategies. And industrial strategies, competition strategies, and trade policies will have to revolve around all of this, and this will require significant financing, a radical change in how markets are structured, again, if the EU is going to be vibrant and if it is going to leave its reliance on traditional sectors that aren't the driving factor of economy anymore. Now, for that, in conjunction with competition law policy, what the report says is that there has to be a particular emphasis on incentives to innovate when engaging in enforcement. And in merger control, there has to be a serious look into innovation potential. I am a tad Schumpeterian, Ioannis argues, and therefore I read this report as Schumpeterian. There is a lot of Schumpeterian bits in there. It assumes that dynamic rivalry driven by innovation is the way to salvation, creative destruction, and all that. But ultimately, what is most important is what my teacher, mentor, master, Eleanor Fox says, which is that you shouldn't throw the baby with the bathwater. But what is the baby, really? So baby was profiled as good enforcement. I would argue that baby now is innovation itself. That's what we should be careful in not throwing out, because that's the true value. We could even compromise a bit on good enforcement so long as we protect the baby. We need to filter the bathwater. There is good stuff in there, yes, and that's good enforcement. But then there's a lot of junk enforcement and a lot of assumption-based enforcement. A lot of enforcement that doesn't stem from a neutral starting point. Enforcement that starts from an assumption that mergers could impede innovation in and of themselves. And now I'm shifting the burden of proof. You tell me, but don't talk to me about synergies and soft stuff. Articulable and calculable, that's what you give me. But you haven't given me anything articulable and calculable in your formulation of the theory of harm. Well, that we will handle along the way. So this is not working anymore. And I think a multidisciplinary study of innovation is necessary in each file, in each merger control matter, which brings us, and these are my last sentences, Chairman.
I hope only for this conference.
Hopefully. Here we need to recognize the role of leapfrogging innovation We need to recognize the potential of short-lived network effects. We need to see the blurred lines between substitution and complementarity. And these cannot be done with the static tools that we use, especially in competition economics analysis in merger control matters today. It really is a whole pretense of a linear understanding of innovation in enforcement at the moment. It's as if you feed some R&D into some magical machine that churns and produces some output of innovative product that you commercialize afterward. This is not how it works. The markets, they are full of skeletons and failures and companies that could not actually reap the benefits of their own innovation, and it's a zigzaggy process, and there will be reversals, feedback loops, user-driven input, platform integration matters, and these cannot be integrated into the analysis through a cost and price-based analysis that we're doing today, is what I'm trying to say. And this is what we're saying with David Thies in our recent article at JetLab of July 22nd.
Thank you very much. I now turn to Nikita, who will discuss more same angle, but from a specific sector point of view, and the financial sector, which is not always the one where we tend to discuss most often these issues.
Thank you very much, and thank you for the invitation. It's a great pleasure to be here. So yeah, indeed. So expanding further, I would like to speak about open banking and open banking regime in the EU that perhaps can provide some useful lessons or reflections for the merger policy as another ex-ante regime, ex-ante regulation that deals with uncertainty. So I imagine here there might be quite a few people who are familiar with open banking regime, but the UK regime, and I will be talking about the EU framework. And so there are a few important differences in the approaches. And the EU open banking framework was adopted in 2015. It is known as a revised Payment Services Directive, also known as the PSD2. And at its core, the PSD2 framework aimed at unbundling the previously established status quo, with banks effectively acting as data gatekeepers of their customers' payment accounts. So this way, the framework aimed at supporting innovation and fair competition by bringing open banking services under the scope of the revised directive, and also establishing the rules of the game for open banking. So just a few words. So what are open banking services? There are two types of innovative services. So these are fintech companies providing two main types of services as defined by the regime: payment initiation services and account information services, both of which rely on access to users' payment account data to offer alternatives to bank and online card payments. So first, payment initiation service providers, essentially they enable additional accessibility of online payments, which are more accessible than online banking and also cheaper than card payments, than credit cards in particular. And the second, the account information service providers offer users an overview of all their bank accounts across multiple banking or financial service providers in one place, in one app. So the main use cases for account information services to individual users have been aggregation and categorization of payment transaction data. So what the framework does, as a framework aimed at facilitating innovation, PSD2 relies on minimum requirements and industry standards to account for the uncertainty, so in particular for rapid development, technological development, and evolving risks, as well as the needs for service providers to offer secure but also user-friendly services. So this way, in addition to market access regulation, so it introduced an authorization regime for those fintechs, the PSD2 also created a technical framework for customer data access and sharing between third-party providers of open banking services and incumbent banks. Now, this is where it becomes really technical, and for the sake of time, we fast forward 5 years. So the framework became fully applicable in 2019. It entered into force. And in 2023, the European Commission tabled a proposal to revise the framework. The current proposal, the PSR, the Payment Services Regulation, so instead of directive, it will be a regulation, it highlights several obstacles to innovation and competition in open banking. The main obstacles consist in frictions resulting from the inconsistent implementation of the two main elements of this framework. First, the user consent requirements that undermine user experience, and also interoperability requirements. So in particular, there's a lack of a standardized open API, open application programming interface, that was supposed to provide a communication interfaces for data sharing between incumbent banks and the third party, the fintech providers. Now, what the Commission is intending to do, so I would like to briefly highlight two important discussions that will help us also understand the lessons or the takeaways from this case study. So first, what undermined innovation and competition objectives of the current framework has been the lack of clarity of rules stemming from the regulatory flexibility. And what this flexibility meant, so it resulted from the regulatory considerations relative to technical feasibility and user friendliness. That's what we try to take into account. The Commission and the EU legislator try to take into account in the context of this uncertainty and the innovative services. As a result, the minimum requirements and numerous exemptions that were part of the framework left the doors open for emergence of obstacles to open banking. And so what the Commission proposes now is to include a list of prohibited obstacles, offering a clear but non-exclusive list of prohibited obstacles to open banking, and essentially limiting this flexibility that was initially granted by the framework. The second distinctive feature or the element of this pro-innovation framework has been industry-led standardization, and that's another important topic of discussion under the proposal. So there, the framework relied on the industry to deliver a single standard of communication, and to date there are several different standards in the EU. There are also several national aggregators offering solutions within one jurisdiction only, such as in the case of Spain, Italy, and France. And this, the status quo undermines the provision of open banking services and impacts innovation and competition in the payment sector. So there's a lot of fragmentation, limited reach of these services, and hence also adoption. So this is an interesting point, because despite of this fragmentation, there is currently no anonymity as to whether we need a uniform API standard in the EU. So some cite potential negative effects on innovation and additional significant costs for the industry. And the innovation argument might sound counterintuitive here, but what many claim is that further top-down, as opposed to industry-led standardization, would instead slow down or even prevent industry from innovating. And part of the argument here is concerns banks' incentives, right? So not the entrants, but the incumbent incentives to come up with additional API functionalities and features. So a single standard would prevent banks from innovating and improving APIs. And the Commission currently seems to agree with these views, suggesting that, yeah, there is no need for a single API standard, like a top-down standard, and instead it should remain as industry-led standardization. Now, so what can we learn from this, or what useful reflections can we derive from this EU open banking example? First, that the dynamic analysis of innovation competition or innovation effects is indispensable for designing an ex-ante intervention. Well, not big news perhaps, but more specifically, so what we see from the example of open banking is how innovation-intense environment reshapes incentives and how it poses challenges for regulation to get the incentives right. So this is illustrated by these two obstacles, the frictions and the lack of the lack of uniform communication standards. So getting the incentives right requires prior analysis of the potential sources of innovation, so entrant or incumbent innovation, which has largely been omitted under the current framework, and also the types of innovations. So are we talking about sustaining or disruptive innovations? And therefore, the dynamic analysis, we can say based on this example that the dynamic analysis is crucial to choose the incentive model, for instance, whether we need compensation schemes or not, and also to better understand and provide safeguards against the potential incumbents' defensive strategies, right? Such as blocking strategies, as we could see here in the current under the current regime. Another important lesson of open banking is the importance of consistent implementation and strict enforcement, and as well as supervisory coordination and conversions. So weak or slow enforcement, and indeed, so these obstacles to open banking were identified already back in 2020 by the European Banking Authority. But yes, so this weak or slow enforcement led, in fact, to irreversible impact on innovation and competition. In case of open banking, this has been the absence of single standard that led to emergence of competing standards. And also, it affected the market structure. So the status quo today is that open banking service providers largely operate within national borders and compete with banks who also adopted similar innovations, and also bank-led consortia that offer or that have established national open banking platforms. Now, whether these outcomes are undesirable is a different question, and perhaps many would argue that it is not, and I would not completely disagree. However, what we see is that, or what we can learn from the EU open banking experiment, is that a lot of innovation in open banking has happened not as being facilitated, but rather we could say that it happened in spite of the regulation being in place. Yeah, I would conclude with that. Thank you.
Thank you very much. It is indeed difficult to find the right balance between the risk of fragmentation, which is an inevitable consequence of flexibility, as is usually offered by the directive model. And that's even worse when some of the member states have a tendency to gold plate their implementation legislation on the one hand, and the risk that a more top-down type regulation creates a straitjacket that may then also limit innovation. Let's hope that we find the balance. Apparently, the sector's experience with the directive model were not very positive. Now we will have to see whether the regulation solves the problem without creating new ones. Thank you. I now would like to give the floor to Stavros. The difference and the relations between merger control and enforcement cases of Articles 101 and 102 have already been mentioned a number of times. And then we really need also to discuss the Towercast saga.
Thank you very much, Jacques, and thanks a lot, Ioannis, for the kind invite. It's a great pleasure and an honor to be in such a fantastic panel. So I was asked to provide an analysis of my 2 cents on the Towercast case. And the point, I would like to make one point, actually. The one point I would like to make is that despite the criticism that this decision sets the national competition authorities to a sea of doubt, actually what it does is offering a welcome yet limited opportunity to deal with dynamic competition and innovation. And to drive this point home, let me first tell you 2 things about the broader context. We have been all discussing about it, and Eleanor did a great job in summarizing what I feel to be as an innovation fetishism or fixation. So we put too much on innovation. We are, to a great extent, agnostic about its sources and its character. We don't really discuss the nature, direction, and diversity or social value of innovation. And we basically consider that the market and scale will generate innovation. However, my point here is that this narrative has performativity, so it has found its way to the case law. We saw it in the judgment that was rendered yesterday, the victory of Meta. We see it also in Trinco. So it's the prospect of monopoly profits which will drive innovation, and innovation will be good for all of us. But if we take innovation seriously, my point is we have to distinguish between sustaining and disruptive innovation. And of course, powerful ecosystems have tremendous incentives to further invest in sustaining, in promoting sustaining innovation, in combinations or incremental innovation within the ecosystem, but also they have far weaker incentives to invest in protecting or facilitating disruptive innovators. Why is that a problem? And why is relevant to Towercast? I will highlight in a second. But this means that the sources of innovation are not only scale, which can be, but also there is innovation coming from above, so from the state, and the work of Mariana Mazzucato and others has shown how state investment and university research has contributed in general purpose technology, but it's also small and nascent innovators that play a pivotal role in the most important part of innovation, which is disruptive innovation. So if competition law is to do something about innovation, has to focus on disruptive innovation. And what do we do so far? Because we hear that the innovation has, we use competition law a lot as a sword, but respectfully, I would disagree with Ioannis here, because from the 2000 to 2025, we have seen more than 1,200 acquisitions by GAFAM, and the intervention rate is below 1% in both sides of the Atlantic. So I don't see much a problem of over-enforcement. If there is any enforcement to begin with, that would be nice. So now let me go to Towercast. So in Towercast, the question was whether a merger, a 3-2 merger in France, which would not trigger the notification thresholds of EUMR and national merger control legislation, could be pursued under Article 102. So can a merger be understood as an abusive practice? The French authority there said, we cannot really move ahead because EUMR, the existence of EUMR, precludes the application of Article 102 to mergers. The court disagreed with that, but the application of Towercast is limited because the court said nothing in EUMR precludes the application of Article 102 to mergers, but which kind of mergers? The mergers that do not trigger the notification thresholds of EUMR and national legislation. So this limited subset of mergers that might be problematic could be captured under Article 102. I don't know about the rest, right? I mean, it's ambiguous, but I would say that at least Advocate General Kokot excludes the possibility of parallel implementation in her opinion. So the test that we can find in Towercast is in paragraph 52, if I remember well. Yeah. So you will have to have three conditions. The company has to be dominant, it has to acquire an actual or potential competitor, and there has to be no other company remaining in the market that is non-dependent on the dominant company. So there is also this criterion of dependency there. So this is the case. Now let's look at quickly, very briefly, two instances of enforcement at national level, because this case activated actually national competition authorities. So a pioneer there is the Belgian Competition Authority that before the ink gets dry on the decision, went after the acquisition of EDPnet by Proximus. So we are talking about telecom providers in Belgium. Proximus was the former state monopoly. It acquired in a bid EDP, the only strong alternative rival that was selling the network but providing wholesale and retail, basically, telecommunication services there, because they were struggling, they were facing financial difficulties, so there was a bid supervised by a court. So Proximus acquired EDP. The Belgian Competition Authority said, we got a problem here. And we have a problem here because the company is strengthening its dominant position in the wholesale market, is acquiring the only credible competitor at wholesale, and also it impedes entry of third parties in the relevant markets. So there was no decision, but there were interim measures, and these interim measures blocked the acquisition. And this is really a pioneer case. The Belgian authority has two other cases where it applies, it extends the Towercast saga in problematic mergers. On the other, now, very close in France, we also have an application of Towercast, and there we have a simpler case, so to speak, because Proximus and ATP was not a really horizontal merger. They were active in different levels of the value chain. But in France, we have the acquisition of Doctolib, of MonDoctor by Doctolib. So now here we are talking about online medical bookings, appointments. So matchmakers between doctors and patients, only two rivals. Doctolib was dominant, consistently above 50% market share in the relevant market, acquired MonDoctor and increased the prices. So the competition authority there found exclusivity clauses, tying practices, and considered that acquiring your number one competitor is abusive. And some of the data that the authority used was internal communication. So they were explicitly saying, let's grab our first rival and kill competition, but also the price increase, which was sustainable post-transaction. So this is how far we have gotten under the Towercast precedent. And now to close, my 2 cents are that the precedent is a welcome improvement. We don't see uncertainty here because what the Belgian and the French Competition Authority did actually makes total sense and is consistent with the theories of harm and the practices we have been witnessing in merger control. But also we should not put too much faith on Towercast because, as I said, Towercast will allow national competition authorities to target only a very limited subset of cases. So we might learn from national competition authorities, and this is great that they are activated, but in order to protect what disruptive innovation through merger control, we need to do more. For example, and I will close with that, for example, we need to think about probabilistic injury, and the precautionary principle is a way to think about probabilistic injury. Another thing we should bear in mind is synergistic injury, so serial acquisitions, individual acts that might create a problem, and ecosystemic theories of harm are a way to think about synergistic injury. And the third one is to focus on effective competitive constraints, which means look at firm level capacity, spillover dynamics, and long-run evolutionary effects to see whether the merger removes from the market a player that has disruptive capacity.
Thank you very much indeed. Now, you get the last word.
I have the last word.
And moreover, you will talk about the people who do have the last word, the judiciary.
So thank you very much for staying till late. And I have to confess, I was very much inspired by the analogy introduced by Eleanor, and that was carried out nicely by Gonenc. And I'm going to work on this analogy. So I have rewritten my presentation in the last 10 minutes. So for me, the baby is good enforcement that protects also and promotes also innovation. And the bathwater is the inevitable uncertainty that comes with forward-looking assessments in dynamic markets, in complete data, probabilistic predictions, and all these that we've been discussing today. So the challenge in this, as in real life, when bathing a baby, is that you cannot keep the baby you cannot hold the baby without getting a bit wet. So the question is not whether uncertainty exists. It exists and it will always exist. The real question for me, no surprise for those who know me well, is an institutional one. Who is responsible for cleaning the bathwater, the murky bathwater? So is it the courts through a more flexible standard of review? So under this approach, courts accept that some mess is inherent to the process of bathing the baby, and they focus on procedural rationality. They acknowledge that innovation cannot be measured with the precision of price effects. The role becomes in ensuring that enforcement is lawful, coherent, evidence-based, but not demanding an impossible level of precision through an elevated standard of proof, like the General Court did in CK Telecoms. And this is roughly the UK CAT model in the Meta-Giffey one. The UK CAT here is saying, don't fear the bathwater, just check that the baby's being handled responsibly, and we will tell you through 5 steps, might have gone a little bit too far in the cross-checking step, that the baby will be safe and handled responsibly. So in the essence here of time, I'm not going to assume, I'm not going to go through the Meta-Giffey one. Now, the European, is it the court institution that will clean, or the European Commission through clearer guidelines and more structured methodologies? Here working a bit ex-ante. The clearer the methodology, the easier it becomes for courts to review it without raising themselves the evidentiary bar too high. Where we are now, at times, I think the EU judiciary sits uncomfortably between the two. At times, it has demanded a very clean water, high evidentiary cogency, non-hypothetical effects, consistent proof. And to this effect, the CK Telecoms Grand Chamber judgment clarifying that the standard of proof is whether the substantial impediment to effective competition is more likely than not. And Advocate General Cocott's statement that any higher standard is inconsistent with ex-ante economic analysis is, for me, quite reassuring. Still, however, cogency of evidence rigorously evaluate a considerable number of factors, whether the evidence relied is factually accurate, reliable, consistent, and that is, I think, where we are. Till I think the Commission mentioned that it's revising the guidelines and embarked on this process. It seems that no one was cleaning the bathwater. So this is an opportunity here. And for me, the courts, building on Fiona's comment, maybe courts should adopt an evidentiary sufficiency under uncertainty standard. And evidence of intent, internal planning, R&D trajectories must be treated as valid and sufficient, not inferior to market share evidence. And the Commission, I think, should pre-clean here the bathwater, and the courts following whether the Commission has followed those guidelines rationally. So why this division of labor works? Because it preserves, I think, good enforcement via the baby. It accepts that uncertainty is unavoidable in dynamic markets, and it ensures that the messy part will be handled by the right institution, and that is the Commission and not the courts.
Thank you very much. This concludes not a debate on the issues. It's just a chapter, but it concludes a very long and, as far as I'm concerned, an extremely interesting afternoon. I hope that you can share that experience also, and that you thank the members of this panel and the previous panels, and of course the organizers.
Let me just say thank you very much, Jacques, for sharing this, and thank you very much to the speakers as well, and particularly to you that stayed up to 6:47. We have only been 17 minutes late, which is, I think, quite unexpected in view of the number of speakers in these different panels. So that is to say that this is an ongoing work from our side, and as you see, we are, as a community of UCL scholars, we are, have very divergent, a pluralist perspective on the topic. We have very different views, and we're still not completely decided also about our views. I mean, our views are, somehow evolving with the data and the empirics. And just to let you know that we have published a report on dynamic effects. This is available on our SSRN web pages and also at the center's web page. We're planning more work on this issue, particularly looking to other dimensions of promoting dynamic effects. For instance, the concept of interoperability and how that could eventually be a way forward and in the whole digital industry, but more generally. So more on that very soon. Our next event is going to be the 20. Do we have an event on Monday, which is the 24th of November, and the topic is
it's consumer protection and the courts,
right?
The courts and consumer protection.
So the course on consumer protection
It's being
chaired by Ioannis. We should have asked Ioannis about that. And then the other event we're organizing is in Paris, the 4th of December, about competition in labor markets. This is a by invitation only event, but please do email me in case you would like to join us. It's during the OECD week, and we'll have quite a number of people participating in this workshop. This is organized together with University of Chicago and Eric Posner. And finally, there's another event, but I think that's probably something which is held in South America. So maybe maybe something to advertise, but to our South American friends. Okay, so thank you very much again, and please join us for a couple of drinks outside. There's a drink reception. Thank you.
And I can really recommend reading the paper Ioannis referred to.